Hello everyone and welcome to Connected With Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm David Walker, a private equity partner in the London office of Latham. And in this episode, we're going to discuss the UK's growing interest in union membership and the roles that unions and works councils and other employee bodies play in shaping private equity transactions. This is, for those of us in London, a very topical issue, and particularly those of us who've had quite some difficulty getting into the office today because of the tube strike. I'm joined by Paul Lawrence, who's also managed to get into the office, and Paul's a member of our snappily titled Executive Compensation, Employment and Benefits practice, and he focuses on employment and pensions issues in the corporate M&A private equity sphere and also in relation to restructurings. And he has particular experience, most recently, of a number of UK public to privates, which we'll talk about later in the podcast. So welcome to the pod, Paul.
Thanks, David. Pleased to join you.
I'm going to start with a top-line trend, which is that I noted in June 2022, the UK TUC made the point, that's the Trade Union Congress, made the point that online inquiries into union membership has jumped 700%. So Paul, tell us why you think there is that interest in trade union membership and also what sectors the appetite for unionization has really focused on.
Yeah, thanks, David. So this increased interest in union membership to a certain extent stems from the numerous bouts of strike action taken by members of the National Union of Rail, Maritime and Transport Workers, as well as others, over issues relating to principally pay and conditions. UK union activity and membership tends to be quite sector specific, and these same sectors also tend to be key targets for acquisitive PE deal teams. Union membership is highest amongst workers employed in heavy industry, manufacturing, transport, automotive and healthcare and education sectors. That said, we may well be seeing unions becoming more commonplace in a wider variety of private sector industries. There has been a steady increase in interest in union membership from UK workers in other sectors, and we might see the recent trend that's been happening in the US towards the unionisation of hospitality and technology businesses making its way over to the UK market.
That's interesting, and I think you're absolutely right that we seem to follow the US in a number of these trends, so it will be interesting to see how that develops. How have you seen regulatory bodies respond to this increased unionization activity?
The key response has been that the UK Parliament recently introduced a bill in response to the increased interest in and activity of these unions. And if passed, this bill would allow the UK government to set minimum service levels, which must be maintained during any future strike action by identified key workers. Now, key workers in this context is expected to include, among others, those in the emergency sector and rail workers. Now, this legislation is at an early stage, but the government's obvious attention and focus on this issue is evidence of the fact that unions are a group who ought to be given appropriate attention from a general employment law and employee relationship perspective, as well as crucially during the course of any proposed M&A activity.
Well, we'll certainly keep an eye on how the bill evolves, and maybe as it develops, there'll be a chance to discuss that on another podcast. But for now, let's turn our attention to private equity. And I'd be interested in your thoughts on the role that unions and works councils play in shaping transactions.
So if a union or other employee representative body is recognised by a target group, then deal teams scoping a transaction should be investigating early in the process if any employment terms, including those relating to pay and or redundancy processes and procedures, are collectively negotiated. Now, by this we mean they're negotiated between an employer and a union or other employee representative body on behalf of all or a group of employees. Deal teams should also be establishing whether any strike action has previously taken place and whether any such future action is either planned or threatened, and whether the proposed transaction will or might trigger any information or consultation rights in favour of a particular union. Now, as well as these specific rights, deal teams should also be considering whether any other legal consultation obligations may exist. This might well be the case, and these may exist irrespective of whether there's any union or works council recognition. For example, on a pure asset deal, employees in many jurisdictions will have the right to be informed and consulted about a proposed transaction by virtue of the GP regulations.
I see. And now, the presence of unions and works councils obviously relevant to most M&A transactions. But I'm interested, particularly given your experience of public to private, how they impact UK P2P deals.
Yeah, that's absolutely right. So the UK Takeover Code requires that certain documents must be made available to employees as well as their representatives, so unions or works councils, about any proposed transaction. The code also provides a right for these unions and employee representatives to publish a publicly available opinion, setting out its assessment and conclusions about the transaction, and specifically its impact on employment and employee-related matters. So early diligence will enable PE acquirers to properly prepare and plan for any necessary union and works council engagement in this regard.
But beyond early diligence, I mean, how else does union engagement impact private equity deals?
Now, there's absolutely no getting away from the fact that engagement can be a time-intensive process, and it may well have an impact upon a transaction structure and deal timetable. So, for example, if a works council is recognised in France, it may be necessary for what is known as a put option structure to be implemented, which can, at times, be time intensive. However, it's also often the case that unions will request a number of assurances from a potential purchaser relating to that acquirer's plans post-acquisition, so far as these relate to and have an impact on workers. So thinking here things such as comfort around future business restructurings, and assurance that large portions of a workforce will not have their roles or terms materially amended as a consequence of a successful transaction.
So I can see how PE bidders may have some concerns around dealing with unions and works councils on transactions. But I'd be interested to go a bit deeper with you and look at how actually the engagement with unions can work to a PE buyer's benefit. So, for example, in some transactions I've been involved in, where a seller has allowed, before the signing of a deal, the PE sponsor to get in front of a works council or a union to explain its business plan and how it will benefit the business as a new owner. That can be a huge advantage because to the buyer, because the seller then will find it difficult to switch horses and go with another buyer when it's introduced all its employees to the bidder we're working for.
Yeah, you're absolutely right, David. Now, as I said before, navigating union and works council arrangements can sometimes add a discrete and potentially labour-intensive work stream to a deal process. But the general positive news for our PE acquirers is that UK unions cannot unilaterally block a transaction. So that's a key thing we ought to always remember. It's worth noting that this is unfortunately not the case in some of our neighbouring EU jurisdictions, such as Netherlands, where unions and works council powers are far more significant. But generally, in our UK messaging, our advice to clients is always that positive and proactive engagement will naturally, typically be well received by those unions. So deal teams should ensure that they're approaching engagement in this way, where consultation is required, or where a union might otherwise become interested in a transaction given the transaction's potential impact on target group employees. And the key thing is there's no particular magic to it. It won't surprise any of our listeners, I'm sure, to hear that approaching any discussions openly and positively is likely to best facilitate successful talks, as well as helping to build a positive relationship with workers and their union representatives at an early stage. We must remember that the transaction phase is just the beginning, and in a post-transaction world, the relationship with the union will be an ongoing one, So clearly getting off on a good footing and building a positive relation early can only be a good thing.
That's really interesting, Paul. I mean, it seems that PE deal teams shouldn't fear embarking on a transaction in which a union is recognized. And indeed, there are circumstances where they can turn that union recognition to their advantage in the particular deal dynamic. So, really appreciate you sharing your thoughts with us on this very topical issue.
Thanks very much for having me. Pleasure to join you.
Thanks very much, everyone, for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcasts on lw.com, Apple Podcasts, Google Podcasts, Spotify, or indeed wherever else you get your podcasts. If you'd like more information about the topics in this podcast, then please email us from the links located in the show description, and we'll happily respond. We hope that you'll join us again next time.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.